Okay, well, thanks everybody for coming to our latest installment of the privacy webinar. We do this one time per quarter, and it always seems like there's a ton moving around in privacy. And what we try to do is really highlight what's happening in the space and really how is it impacting the industry of media, consumer, and advertising and the impact that it has. So if you're new to the webinar, I'm Neil Sweeney. I'm the founder of Reklaim. If you're not familiar with Reklaim, we're a company that really focuses on trying to provide consumers with access to their data. And should they choose to, they can option it for sale and or sign up to actually have it removed from various different channels. And with that in mind, I'll kind of turn it over to Mackenzie to introduce herself and her place in the ecosystem.
Hi, everyone. My name is Mackenzie Thompson. I am an attorney at In-House Privacy, a boutique law firm based in San Francisco that focuses on privacy. We tend to have a lot of clients in technology and ad tech. So I'm here today to take that legal angle. Of course, I speak only for myself.
Great. Ben, you're up next.
Hey, Ben Isaacson. I'm a principal with In-House Privacy. I work with Mackenzie, and I've been in the privacy space since 1996.
Awesome. And then this quarter, the special guest is Tony. So we try to bring somebody in every quarter to give us a different bit of a different vantage point. So Tony, thanks for carving out a little bit of your day for us. Why don't you introduce yourself, your organization, and what you and the organization are focused on?
Yeah, Neil, thanks so much for having me. I'm Tony Ficarota. I'm Vice President and General Counsel at the Network Advertising Initiative, the NAI. The NAI is the leading self-regulatory organization focused on privacy for advertising technology. So we're a member-based organization. We usually have somewhere between 80 and 100 ad tech companies that want to differentiate themselves as being privacy leaders by adhering to our self-regulatory framework that promotes privacy. We also have working groups that develop best practices for privacy issues that impact business. We also spend a lot of time engaging with regulators and policymakers about their priorities and how our members are complying with their laws. So thanks for having me.
Amazing. Okay, so let's start at the obvious one, which is the patchwork framework of new state level privacy laws. So this is the one thing that seems to be moving around probably at the fastest rate. So I don't know, Mackenzie, maybe we'll start with you. Do you want to just give kind of a brief overview of what's been happening here specifically as it relates to some of the new regulations that have been manifesting at the state level? And then once we've got that kind of framework in place, maybe we can zero in on everyone's favorite state as it relates to privacy is California. And there's a ton going on there as it relates to the new legislation, some pretty onerous things are being put forward, the Delete Act, et cetera. And then whether it's Ben or Tony, feel free to kind of maybe jump in with Mackenzie once she provides the overview. Once we've got that, I think we can then start to look at what are sort of some of the things that are happening at these other states. But let's start with the overarching changes at the state level and bend ourselves into California.
Yes. So this is very timely for me. I just worked on a readiness record going through every state privacy law, and I counted it between all of the laws and the amendments and the implementing rules. I was at 27 laws, not including data broker laws, not including health laws. But we're seeing crazy growth. I think it's 19 states by January next year have in effect privacy laws. You mentioned there are amendments to these laws coming out as well. So like Oregon has had an established privacy law for about a year now, and they just passed an amendment that comes into effect in July that affects things. It bans the sale of precise geolocation data. It bans the sale of minors data 16 and under. I also want to call out Maryland. Maryland has a number of heightened provisions that we don't see in this like general blueprint of privacy laws. They have a ban on targeted advertising to minors under 18. They have a prohibition on selling sensitive data full stop. And they have this unique provision around data minimization. We see that the general landscape says that data minimization principles are really, keep what's reasonably necessary, but Maryland goes much further and only requires or only permits the collection process and sharing of sensitive data if strictly necessary to provide a specific product or service requested by the consumer. And I think we'll get into that later about consent and cookies and ad tech and what that means for cookie banners. But generally, we're seeing states start to compete with each other. And I know, Ben, you have some opinions on that with all these amendments of where they're one-upping each other. So maybe you want to jump in there.
Yeah, I mean, there's been just a constant stream of activity from states, again, that even already have laws on the books that are, trying to emulate a lot of the other states. And there's, starting to be this sort of tit for tat happening at some of these state privacy, these legislatures where they're trying to be the strongest privacy laws in the country. And so Maryland being a good example of that. And but Massachusetts is in the middle of their debates right now, and they're looking like they're gonna, go one up. New Jersey just issued new proposed regulations yesterday, I think it was, that again, trying to enhance their existing laws. And so it's this constant stream of pushing towards what may eventually look more like Europe. And a much more, consistent and comprehensive law than this sort of patchwork that we have right now going on.
Do you think that it's inevitable that we eventually get to a European GDPR type law here in the United States, and whether it's if that one-upping continues, that somebody just bends in totally to that and sets the new benchmark?
I mean, most companies, try and reach the top, state, right? Like they're, California has historically been sort of the number one benchmark state, but that's changing quite a bit, depending on the category of data that you're collecting. So I don't know. I think, America is so unique in the patchwork that we have of laws that, just because, I don't know, Maine or Massachusetts or Maryland have some, high bar doesn't necessarily mean that companies may still not use California as their benchmark, or just try and geofence and try and, figure out how to engage. It's ultimately going to be sort of impossible, I think, to be perfect, without going to that top benchmark law. As a federal law, essentially, even if it's just one state.
Tony, any comments or thoughts on that?
Yeah, I have some observations, just like in terms of the trend line Ben was speaking to. I think that even with CCPA, which is what a lot of folks key to as the first US privacy law, there's more or less a laissez-faire baseline for CCPA. Disclose what you're doing, do what you say what you do. You can sell data, you can use it for targeted advertising. Just listen if a consumer says to opt out. So it's like anything goes unless, right? Like unless the consumer opts out, unless you fail to disclose it. But this shift that Ben is pointing to is that some states are saying we are not going to allow certain commercial activity with data, full stop. We don't care if you got consent. We don't care if the consumer opted out. We don't care if you disclosed it and put it across a banner in the front of your page. You cannot sell consumers precise location data. That's not laissez-faire. In Maryland, you're not allowed to collect and use any sensitive data unless it is strictly necessary to give the consumer what they asked for. That's not laissez-faire. So again, like whether many states continue to follow along with that, I think that's an open question. I think that's being determined in state houses like as we speak, depending on, how well companies advocate for their interests, how well consumer advocates are in there advocating for what they view as consumer interests. That drama is playing out right now, but the trend line is shifting toward less laissez-faire. That would be my observation.
Yeah, so on that, I mean, and this is maybe a good benchmark. At the NAI, there's so many companies that are members of the NAI. And one of the things that we see in the market quite a bit is with this rapid iteration of privacy laws that the overall market is not kind of keeping up. And whether that's a laissez-faire attitude or it's a lack of understanding, maybe kind of if you can talk to that, which is, there's so many companies that are operating in the data and marketing space whose whole business is rooted in data. Now that there's this proliferation of state level laws where, as you mentioned, they're becoming increasingly more aggressive, it puts a ton of pressure on these companies to actually stay up to date, to change. But in a lot of cases, it's fundamentally removing business lines. So, just using location. If you can't sell location data and you're a location aggregator, that's a serious problem. So maybe talk to kind of how you are seeing, like what are we seeing from various companies and their understanding of these new laws, and what are these companies doing to try to stay up to date, to change, knowing that it seems to be changing literally kind of quarter over quarter?
Yeah, it's a really good question. And so part of what we do as a self-regulatory organization is try to help our members with this. And we've undergone some major changes to our program in the last year to try to adjust to this new state law environment, where we view more of what companies need right now is to have good processes in place, to have mature data governance programs that can adapt to all these changes that are going on, and to participate in annual privacy reviews with our staff to help them understand what's happening and what you need to focus on, or what's helpful to focus on. And then if we identify things, we can refer them to, in-house privacy or their favorite privacy lawyers to help them solve that specific issue. But you're right that we are dealing with this intersection of privacy and business challenges that is existential for some companies, and location data companies are a good example of that. So what we do is we kind of take a two-pronged approach. One of them is that we try to develop industry best practices that we think are actually defensible and that strike an appropriate balance between consumer privacy interests and business interests. So the NAI has a document out called the Voluntary Enhanced Standards for Location Service Providers, where we've acknowledged that there are some use cases for location data that raise such intense privacy risks that the commercial benefit just isn't worth it. If you want to track people to abortion clinics or to mental health facilities or to transgender care facilities, there are such intense consumer privacy risks that are raised by that kind of tracking that it shouldn't be allowed. So we've created a voluntary standard where companies can say we don't do this, and there's an industry standard that we can commit to that says we don't do this. So that's one way to kind of like raise the bar and to try to allay those concerns before they become concerns. But if state houses are out there saying like this is important to us and we're not going to allow it, well, we go to those state houses and we go to those regulators and promote our standards and say you don't have to ban it. There's a more responsible way to do it, and we provided a model for how you to do it. Now, we weren't successful in Oregon. Oregon went ahead and passed the ban anyway, but there are other states in play that we're working with this year to try to promote responsible industry standards that aren't completely laissez-faire, but they preserve the core use cases for location data while acknowledging that there are some things that are kind of beyond the pale.
So just on that, the ban specifically in Oregon was what?
You can't sell precise location data. Ben and Mackenzie might correct me. It might be sensitive data writ large, but it's at least precise location data. Yeah. So if you have long data tied to a device ID, that is not for sale for Oregon residents. If you sell that data sourced from an Oregon resident, then you've violated their privacy law.
We've seen this, and we'll kind of come back to that because I have a couple of like follow-on questions. We've seen this trend increasingly in the market where historical companies, traditional DMPs, who've housed this data and made it for sale, are at this inflection point where, because they don't have any interaction with the consumer, both opt-in and opt-out, these categories which they used to house in their kind of data warehouses, they've just flat out removed. And so what we've seen is that the traditional DMP doesn't have a multicultural data. Due to fair lending, there's no household income data in a lot of these platforms. And so what's changing in the market has been this, I kind of call it this breakdown of the value chain, where the demand for that data, because it's been ingrained for so many years, remains strong, but the distribution of that data has sort of evaporated. And it's created this chaos in the market where more and more of these categories are being kind of dropped from the market, which, kind of back to your point, Tony, about the existential threat for the businesses, is that, to me, just removing categories of data as a large data company seems like a short-term solution. But if the trend is that we are increasingly moving down this path where there's more consumer inclusion and opt-in, so this plan is like, well, is the plan then to just continue to remove category after category after category until there's nothing left? Which begs the question, it's easy to see the pressure that a location firm would be on, but when you kind of zoom out, how does a traditional DMP, which has been the heartbeat of the ad tech industry for so long, function in this new world where you're increasingly kind of moving towards opt in and opt out? And they're already starting to struggle with that. I don't know if any of you guys have an opinion on that or if you see the same thing.
I think there's it's a really difficult thing to say, especially as a lawyer, but I see clients or companies generally making sort of a risk assessment around the potential enforceability of some of these laws in conjunction with the utility of that data. And even, the gray areas of interpretation, of whether or not the data is really in scope for those enforcement actions or not. Again, like we've talked about quite a bit, inferences and what inferences mean, and how it's defined in a particular state law, and the huge difference between a lot of these definitions across states. And so if you're just going to say, okay, we're just going to wipe out all of our inference data about, I don't know, health information, just because, one state like Washington sort of maybe includes a broad definition of it, so we're not going to, use inferences anywhere, isn't a utility, trade-off that most companies are willing to make, because they, if I'm a health-related marketer, again, we're not talking about protected health information. We're talking about, I don't know, like, skin cream that, might have, medical benefits, right? That might be over the counter kind of stuff. But again, this draconian sort of Washington law that sets that tone that skin cream is probably in scope, but we haven't seen an enforcement action from Washington yet. We haven't seen private rights of actions, with lawsuits related to skin cream type products. So there is this debate that's happening now. And we should talk about some of the enforcement actions that are maybe starting to edge into that debate, especially California's, where there are sort of some clear guardrails starting to take place with some of those enforcement actions. But I think it could be years before we see that utility, regulation trade-off really, fully wipe out, I guess. But to your point, certain categories of data.
Yeah, I mean, I think what's interesting is that there's a difference between maybe kind of the interpretation or the true understanding of the law, and then kind of how it's manifesting in these businesses. Like we've seen kind of billion-dollar SSPs decide no health data in our platform anymore. And that's a pretty competitive industry. The SSPs, one is basically saying we're not going to do it. We've seen full healthcare marketing agencies say there's a half a dozen states we're not going to target in at all. Which, again, the question is that if you're an advertising agency and you're hired to work on behalf of a brand, how are you eliminating 3, 4, 5, 6 states and kind of still doing your job? We've seen global DSPs remove the state of Washington from any and all ad impressions. We're sort of seeing this kind of pop up here and there, where DMPs are removing SPI, SSPs are removing health, agencies are like blocking states, DSPs are. So there's this patchwork where now your ability to execute a campaign on behalf of client X is not as seamless as before. And like there's some very strange conflicts. Like as an example, you could argue that multicultural data being reclassified as sensitive has made it, there's never been a bigger need for multicultural data, but yet there's never been a harder time to actually find it, which runs exactly in the opposite direction of marketing. So some of these laws that are coming in, I feel like they're coming in for the right reasons, but the downstream impact, it's actually having a negative effect. Trying to market to somebody from a multicultural perspective right now in America has never been harder, but yet 40 to 50% of the population identifies with being in that category. So how are marketers' platforms doing their job? It's just, there's a big fallout here as it relates to some of these individual changes. Okay, let's keep moving. Ben, you mentioned kind of California. There's I know that there was some new legislation that was looking for comments. And there are some pretty onerous things as it relates to that legislation that is being proposed in California. I flippantly always say, like, if you kind of are on the wrong end of this and it's sort of the letter of the law, the fines could potentially bankrupt your company if you're not careful. So let's maybe kind of speak to what's happening in California, what they're trying to kind of put through, and sort of what we like and don't like about that kind of legislation and its impact.
Yeah, I'll kick it off because yesterday was the deadline for the CPPA, request for comments on the Delete Act, which regulates data brokers, which feels like a very niche type thing that, again, I don't think has gotten the attention that it deserves, because in those regulations, it includes a very broad definition now of who could be a data broker. And really, again, it's a subjective intent standard now that the CPPA proposed in these new regulations, which says that if you visit a website, your intent is to interact with that website, but not all of the companies that might be associated with the website, in particular, like third-party advertising services. So when you visit, an e-commerce company, you really aren't intending to interact with, let's just say Meta or Google. And so if those companies, now granted, those companies are a little more walled garden, but let's just, again, Google, for example, has an ad network, allows for retargeting on other websites and has a cookie on their website. And I'll let Tony speak to this more than me because it's his membership focus. But like the fact is, like, in my opinion, I think Google is now deemed a data broker under these new regulations or draft regulations. And the same goes for any companies that help other companies purchase third-party data and use that third-party data for for marketing purposes. And so ad agencies, for example, are often tasked with, hey, go buy me a bunch of data, combine that data into a list, and we'll go send a direct mail piece, and you can take a little piece of the action on top, as part of your fee structure. Those agencies now would be deemed data brokers as well. Now, why this is so important? This isn't just a registration law, even though there's fees for registration that are not insignificant. It's $6,600 in California now, but it's in the law, in the text of the law. It's not a regulation. It's in the text. Is a statutory penalty of $200 per day, per deletion per day that isn't applied. Now, again, we see a lot of statutory, obligations in state privacy laws, but this one has a kicker, which is next year, August 1st, 2026, is the implementation of this deletion request and opt-out platform, this drop mechanism, which says that every data broker must be registered and must apply this list. And if you don't register and you don't apply the list, then you're going to get that $200 per deletion per day fine. And if there's 1 million people on the California registry, which I think there's a good chance it will be in a matter of months or years, that fine could be hundreds of millions of dollars. And again, that's just a statutory fine. There's no appeal. There's no challenges. Like, you're just going to get fined. And again, I don't know who could swallow. Maybe Google could, but swallow that kind of fine. So this is perhaps, again, I've said it, like on LinkedIn and stuff, like, I think the most, powerful state privacy law on the books today, because of that statutory penalty, and the fact that there are so many companies that aren't registered, who probably won't be registered as of August 1st next year, and could just get fined as a statement that the CPPA makes to the industry.
Yeah.
So,
And that do you think that because it's a combination of the fine and the registry and those two together, not so much the actual privacy legislation kind of that's in California? Because my interpretation of California is that some privacy legislation, like Mackenzie, you've kind of talked about Maryland in the past, like that's actually probably more onerous than California, but maybe not as dangerous because it doesn't have the registry and the actual fine. So it's important distinction between the two.
well, I think the biggest thing about California is clearly that they have an agency devoted to enforcement. The only state agency in the country that has a privacy regulator that has an enforcement budget to with staff to go find those. And again, California has found, I think it's at least 6 different companies now that were not registered as of 2025, and has fined them $50,000+ each, or tens of thousands of dollars for not registering. So they've already set the tone that they can go find these companies and enforce against them, and they certainly will do that when the drop comes into effect next year.
Then I wanted
So
to add on to
yeah,
that too, if I may. Yeah, so I wanted to add some insight that I got because I sat down and interviewed Mike Macco, who's the director of enforcement at the CPPA a couple of weeks ago, and asked him about some of these issues. And he referred to personal data as enriched uranium. So if that gives you a sense of like how they're viewing this, like I don't think he meant it to sound terrible. He's like, look, it's potentially very powerful, but also very dangerous. But he called it's like enriched uranium. And he really emphasized to me that he views data broker registration as a priority of enforcement for his agency, which has been said tracks the fact that they've done, I think, 7 enforcement actions in the last 6 months for folks that are not registered. In one case, the data broker chose to shut down their operations instead of try to pay the fine. And these are for fines in the tens of thousands of dollars. But once the drop comes online, those fines are going to go up by an order of magnitude at least. So you have an agency that is specifically and aggressively going after data brokers, broadly defined. And it seems like they're perfectly happy to put them out of business if they can catch them as being unregistered. And their ability to do that with increased fines is going up. Also agree with Ben's point that part of their strategy here is to try to single out business lines that sound scary, data broker, sensitive information, like that's the bad stuff. That's the enriched uranium there. But they're defining those terms so broadly that they're capturing, more or less benign general commercial use data. So it sounds like it's really focused on, oh, it's just like the bad data brokers, it's just bad sensitive data, but it's bringing in a lot more than that. So
yeah.
that's kind of my gloss on that observation, Ben.
It kind of, I mean, your previous point when we were talking about location, nobody in their right mind thinks it's a good idea to be tracking people to abortion clinics or, like that's just if you're doing that, you're asking for trouble. But I think like the flip side of that is there's inherent value in location data. There's entire products and industries and services that have basically been created primarily around location data. Like think about DoorDash, Lyft, Uber, like these businesses do not exist without location. And so like there's a fine line between kind of what is being used in a nefarious way and then what is actually providing a ton of value. I think, back to your kind of point of, I don't think that there's a lot of, I don't think anybody's going to shed a tear for kind of data brokers potentially being removed, but the downstream kind of collateral damage associated with this kind of very wide definition of what is constituting a data broker tends to create, a ton of chaos for those that are kind of those that are trying to operate in the space. So,
Can I just
if
give you an example of that?
yeah,
So like Ben was talking about how it has to do with consumer intent and like what context the data was collected in. But one example that seems pretty clearly to be pulled in is you are an advertiser, like you're a retailer, maybe you're a B2C advertiser, and a consumer comes to your website and buys something. You have a first party relationship. Um, you're going to be sending information through the ad tech ecosystem to retarget them, right? Are you a data broker? Well, if you've brought in any third-party data to enrich that consumer profile, you have now collected information that you have not collected from the consumer, and you're selling information about the consumer. So I think there's a pretty fair case that the CPPA will say, yes, you are a data broker. You're like, well, I didn't think I was a data broker. I'm a retailer, right? But you bought third-party data, so now you've got information you didn't collect directly from the consumer. That gets you in, or that gives them a hook into the definition. So it is like to your point, it can get very broad, and that's one of the things we're most concerned about.
yeah, I mean, I see that there's going to be a ton of fallout associated to this. Just one of the questions, from kind of the group here. It's the question is if you're an agency and you don't touch any data, then you would not have to register as a data broker. Yes, no, or is it depends? The thoughts on that, guys?
Mackenzie, do you want to take that one?
I was going to pass it off to you. I know you're very passionate about it. Potentially, you could be in scope. One of the comments we made, or Ben made in our comments to the CPPA, was to carve out an exemption for agencies. But Ben, I mean, you can speak better to it than I can.
Yeah, I think touch is you use the word touch, right? And, there are a lot of services now that, again, don't actually, again, physically or whatever you want to call it, have like a database or some, they don't pull the data into their system. They might use like a data clean room even, which is sort of seen as a privacy, panacea, but really isn't, because again, if the agency is procuring the data, and even if that data goes from the data broker to the clean room, and then the advertiser uses that data in the clean room, but the agency is the one that procured the data. They have the insertion order, or license, they're maybe pushing it from different sources, and they're getting, some, again, fee structure associated with the data that they're reselling to the client, which is fairly common. They would be a data broker. So
Mm.
it's so important now to have really proper legal commercial controls and product and monetization limits on how that data is bought and sold, to make sure that the agency is still a service provider, let's call it, versus a really a reseller.
So I want to move on to the other kind of, I think we focus a lot on California, and sometimes people forget that there's a lot of other things happening in the other states. Just quickly before we move to the other states, as it relates to California and some of this, the information on the enforcement action and some of the commentary that's been going into CCPA, what's our belief as to where we think this lands? Are these comments, do we feel that there's going to be a massive iteration here, there's going to be a massive change, or is this just kind of going through the motions that there's lots of comments, they'll be ignored, and that what we're seeing right now as being proposed for the Delete Act next year and this legislation is pretty much going to manifest as a carbon copy?
I have a very snarky response to this, which is that yesterday they had the hearing, and I was the only person to comment on these regulations publicly, at least. Now, no, I'm sure a lot of people, maybe Tony could speak to, if NAI submitted comments, but like, I'm sure there are lots of written comments, but as far as oral comments go, I was literally the only person to say anything. So I kind of doubt there's going to be a whole lot of change happening here.
No, Ben, I'm glad you were there. I was putting the finishing touches on our written comments. I didn't have time to attend the hearing because I was writing our written comments, but I'm glad you were there to speak up. But yeah, it's hard to roll back privacy laws in California. The CCPA, I think, says that you can't amend the CCPA to make it less privacy protective unless you have a supermajority. So there has to be a lot of support for rolling back privacy protections in California. That's not great. Even if there were unintended consequences, it would be hard to unring the bell. So it's a tough situation.
Yeah. So it sounds like basically there's not going to be many changes to the California bill, and it's all because of Ben's comments that were not listened to.
Hey,
So it's all your
if we
fault,
get
Ben.
those exemptions and we get a cure
Yeah, it's
period.
all your fault, Ben. There you
We
go.
look, we have seen the agency respond to real pressure campaigns. So what we have here is a regulatory agency that is empowered by a law to write specific regulations about how to implement the law. I think that by and large, the CPPA has been very aggressive in how they're interpreting their laws. They're trying to take as expansive an interpretation as they can. And in some cases, they have had enough outcry from the business community that they have pulled back. There was a campaign for the automated decision-making regulations. We haven't talked about those, but it was expected to have a big impact on the big tech companies. So they have enough clout in California that they went to the governor, they went to the legislature. There was a group of legislatures that sent a letter to the CPPA. Usually it's just guys like Ben and I that are sending letters to the CPPA, but in this case, it was also a group of legislatures and the governor saying, are you sure you know what you're doing with this? It seems like you're taking this pretty far. Aren't you stepping on the toes of the legislature when you're governing AI and automated decision making with your rulemaking rather than letting us make policy decisions about it at the legislature? And you actually did see some very significant changes to the regulations in that case. For the data broker regulations that we're talking about now, I have not seen that same level of participation and outcry. I'm not saying it isn't deserved, but I haven't seen it. So the chances of getting significant changes, I think, are low. We might get some things around the margins. They're not completely unreasonable. They'll listen to reasonable arguments, but it's usually things around the margins and not the meat of what they're asking for.
Interesting. So I think we've done enough on California. Let's maybe move to kind of some of the other states. And I don't think we need to get into all 19 states, but there's clearly a handful of these states that are doing things similar to California in the sense that they have registries and they're enforcing laws. Um, do we want to do a quick little summary on what's happening there and cherry pick those actions and or states that we think are going to be have a pretty big impact that maybe the average person in the space is not really following along with? I don't know, Mackenzie, and you're always kind of my
Yeah.
go-to resource on this one, so I'll kind of look for you here.
I'm always in the weeds with the state laws. Yeah, I mean, there's like the provisions that are exceptional that we talked about at the beginning, like the prohibition on sensitive data sales in Maryland and targeted advertising to minors in Oregon and Maryland, and then the precise geolocation prohibition for sale in Oregon. But then there's also, I think, enforcement has a big part in an impact of a law. So like Texas, we know is very active in their enforcement, not just their privacy law, but their data broker law too. We've seen them mine the California data broker registry. And if you're not registered in Texas, but you are in California, they send a notice to you and say, well, why aren't you registered here? And they'll really get into the weeds and make you provide like your InfoSec policy, because that's one of the provisions of that data broker law. And then also the enforcement action that Tony mentioned earlier, that was a huge fine. They're very active in, for that reason, they'll make a big impact. I think New Jersey is also very active. We've briefly mentioned that they have some proposed rules that are pretty different. They're a higher standard than the other laws, like disclosing your retention periods in your privacy policy, which we don't have in other states. Loyalty programs are regulated with their privacy law. I've got my little cheat sheet next to me. They're also going hard on dark patterns for cookie banners, just like California is. So I think of the enforcing states, like we're seeing it's California, Texas, and New Jersey so far. So those are going to be states that you want to be extra compliant with.
Interesting. Gents, anything to comment on or to add to that?
I mean, again, I think there's certain categories. I mean, if you're targeting or you in any way marketing to teenagers, this is a category that across states there's age appropriate design codes which intersect with privacy laws now, and again, as Mackenzie mentioned, like, there's just a lot of focus that again, there's very little opposition to in terms of raising the bar from COPPA, which is really, under 13, to teenagers, and really bring that up, significantly. So that's a huge category that I would strongly advise any companies targeting in that space to have.
Is that 19 and under, or is it a subset of that? Is it 17 or under? Like the teenager is defined as what? Sub like 19 and below?
Not 19 now, I would say under 18, yeah.
Under 18. Okay. Yeah. Interesting. And just for my own clarity, outside of California, none of these other states have sort of this typical kind of enforcement that we're seeing in California elsewhere. There's no suggestion that Virginia or New Jersey has this, $200 a day fine or anything like that. We're not seeing that manifest in any other states as of yet.
Not the fines that I've seen, though.
Okay. We've got a few more minutes here. I'm conscious of everybody's time. One thing that I did want to kind of turn our attention to is sort of the collision course of privacy and AI. We've talked about this in kind of previous webinars. One thing I did want to kind of focus on is sort of this new big, beautiful bill that is being talked about quite a bit. And there's a few things I kind of wanted to get my head wrapped around. Is that, from the way I understand it, is that there is a 10-year moratorium on state and local AI laws. What does that, mean? And secondly, is how does this bill kind of conflict with some of the things that we're talking about at the actual state level? So we're doing all these changes to state level privacy. Are these getting neutralized by this bill? And what does this bill mean for kind of consumer privacy? Because the very sort of simple interpretation seems like it basically steamrolls consumer privacy and puts a moratorium on that for 10 years. Maybe if you guys can kind of comment on that, that would be helpful.
Uh, yeah, I mean, I guess I could start. I mean, I think first of all, there already are a number of AI laws on the books, and as well as, even Tony mentioned automated decision making, which could also be deemed AI in some contexts. California's got a number of AI laws. Colorado's got a robust AI law. And so the idea that there would be a moratorium, again, against existing laws is at this early stage is extremely unique. And, this is a Republican budget bill, and this is not necessarily, historically has not been a Republican value to preempt all state rights. But I think, the most important thing is, AI is just so rapidly evolving that to say, there needs to be a moratorium at a point where, it's like I think I mentioned an email to you, like, it's like we're really at sort of the Model A car right now. Yes, it's a vehicle, it works, but to say that, we're going to have a moratorium on 10 years is like saying we're not going to have seat belts in these cars until that car reaches Mach speed. Like, that's how fast things are going to happen between now and 10 years from now. AI will be at Mach speed. And if you listen to some of the experts, we're talking about, AGI being in effect in 10 years, which is obviously, has very broad ramifications for our society. I think there's what we've seen in the last few days even is tremendous pushback, from members of the Senate, including like Rand Paul and others, where, historically they would just back something like this. There's a lot of pushback, and it sounds like, I think JD Vance even yesterday said he doesn't think the moratorium is going to be included in the final version of this bill. So, we'll see where it goes, but it looks like the momentum is waning for it.
Right. And then just to be clear, so the way it's being presented, does that or does that not conflict with state law, with some of the privacy-driven stuff at the state law, or is it complementary to that?
I mean, it would preempt like Colorado's law from coming into effect next year, which is it's scheduled to do. So that's my. I mean, it would still come into effect, but it would be unenforceable, I think was the term of how they're approaching it.
And some of it might have to do with, just getting into the nitty gritty of the definitions, like what do they mean by AI? What does California mean by automated decision making? That there are probably areas of overlap, but there may be areas of independence where even if it were to pass, those rules wouldn't be rolled back. So I agree with Ben that there would be a huge impact, but ad tech has been doing automated decision making forever, right? Like you collect data, you optimize, you use machine learning, you change the ads you show consumers based on those automated processes. You're making a decision about them. Is that the kind of AI that there's a deregulatory push for? Like maybe, but you have to look at the definitions, and you'll have different lawyers tell you different things probably. So like I just don't know yet.
Yeah, that always gets snarky comments from the engineers when they sort of say that's actually machine learning, not AI. It's not necessarily the same thing. So like there tends to be a lot of debates around that. Just one thing that
just to add though, I mean, there are many laws on the books today where AI would be used, where the law would still preempt any, again, anything that comes out of Congress here, in particular the FCRA, as well as like anti-discrimination, for housing or employment purposes under, different, California, other laws that regulate, either credit or reputation or other kind of categories. So, that's not going to, anything that happens here isn't going to change existing law that, just regulates those kind of traditional practices.
Right. So just as we start to wrap up, last question, maybe I always like to frame this up as what happened in the space here that we thought wasn't going to happen. So what did we miss on? And looking forward, what do we think is the thing that might happen that no one's really paying attention to? So I don't want to put anybody on the spot. They don't have that like off the top of their head. So I'll defer to you all to determine who wants to kind of go first. And you don't have to do both sides of that. You can just pick one or the other if you choose.
I mean, something we've been working closely, or tracking closely, is there's a California law, SB 690, which passed already out of, I guess, the House. It's going to the state Senate. and explicitly amends the California Invasion of Privacy Act so that the California the CCPA, would really override the CIPA law. And the reason this is so important is, there have been tens of thousands, maybe even hundreds of thousands, I don't know, of letters sent by enterprising plaintiffs' attorneys to any website publisher saying you violated CIPA by having a pixel tag on your website. And to great success, many of these letters have been accompanied by a settlement that results in $5, $10, $50,000 going to these plaintiffs' attorneys in exchange for not following through on a lawsuit. The CIPA private right of action is pretty broad, and so a number of these plaintiffs have been actually filing claims in court or in arbitration. So it's been like this death by paper cut kind of thing for years now. So we're finally seeing some hopefully momentum in the legislature to make this go away. But until that happens, even in the last few weeks, we've seen a lot of letters sent to just random websites, and they're just spraying and praying, to try and get a response. It's like they're like fishing for people to respond to these letters. So it's unfortunate, but it's hopefully it'll get fixed.
Interesting. Tony, got anything that you missed on or you think is going to happen that no one's paying attention to?
Yeah, so we haven't touched on it yet. I hope people are paying attention to it, but the things I would point to for kind of the ad tech and marketing space are federal laws and rules. One is the Protecting Americans' Data from Foreign Adversaries Act. The other is the DOJ rule prohibiting bulk sales of U.S. sensitive personal data to countries of concern. So those are national security rules. They're kind of in the vein of, we are worried from a kind of counterintelligence and national security perspective about U.S. adversaries getting access to data about U.S. persons that can have consequences for national security. They've written those rules very broadly that they are anticipated to cover a lot of standard ad tech data flows because they happen at scale, they happen in bulk, so they meet the relevant thresholds. That means that companies are having to start to pay attention to whether their counterparties are U.S. persons or not. And if they're not, having to figure out whether they're headquartered in a country of concern like Venezuela or China or Russia, just to give a couple of examples. That's all new for U.S. companies, having to think about cross-border data transfers, but it's something that isn't going to go away, I think. And for the DOJ rule, it's the first law like this we have that has criminal penalties. So there's definitely going to be skin in the game. It's not just a fine you can brush off. So I would say watch that space.
Wow, interesting. Mackenzie, you get the last word here.
All right. I think we're going to see more states introduce copycat bills to the California's Delete Act, and have drop mechanisms for each state. Federally, I think it was last year, there was a copycat law that stalled out, but we have seen other states introduce similar bills. So I think it might be onus on data brokers in multiple states.
Interesting. Okay, so we're out of time. Thanks again for everybody for joining the webinar and for the panelists here. Just as we sign off, if people who've attended this want to reach out to you, any of you guys, for your services, autograph, or to hear about your comments on California, where can they reach you? Tony, we'll kind of start with you.
Sure. You can visit the NAI's website, thenai.org, or you can email me, tony@thenai.org, or you can find me on LinkedIn. I'm always happy to chat about this stuff and share what I know. So feel free to reach out.
Amazing. Mackenzie?
I'm on LinkedIn as well. Also email Mackenzie@inhouseprivacy.com.
Amazing. Ben?
Same. I'm pretty active on LinkedIn. Love engaging with people, but also ben@inhouseprivacy.com.
Perfect. And for me, you can reach me at neil@reclaimyours.com. So thanks again, everybody, for carving out 45, 50 minutes of your time in the middle of the week. We'll see you next quarter. Thanks, everyone.
Thank you.
Thank you.